And we are now going to enter the legal space, and we have 3 lawyers on the show today. So I will start the conversation though from lawyer Yaopong. Now, this week was a very touchy week for Mr. Martin Amidu, because the week started when his fate was going to be decided by the Supreme Court. But on Tuesday, he heard good news, because the Supreme Court, by a majority decision of 5-2, said that Mr. Amidu was eligible to operate as special prosecutor, as his appointment did not contravene the 1992 Constitution. Now, the suit was filed by Dr. Dominic Akuritinga Ayine, who is also a member of parliament. He's MP for Bolga East, a former deputy attorney general. And the majority decision came from Justices Kwesi Eniyaboa, that's the CJ himself, Paul Bafo-Boni, Samuel Kiema Fusao, and Namegacha and Professor Nia Shikote, while Justice Nasiru Sule-Gbadegbe and Agnes Doji dissented. And after that, we heard from Dr. Dominic Ayine, who expressed his disappointment about the ruling. We've also heard from other lawyers who've written and said this could set a precedent that might come back to bite us. Others have also said, well, this is the correct interpretation of the Constitution, and it is high time we separate such office holders from the general populace. So we'll hear Dr. Dominic Ayine. He went to court. So let's hear what he has to say, and then we can begin the conversation.
Yes, I must say I am extremely surprised by the decision of the court today, dismissing my writ by 5 to majority in favor of the Attorney General. As you would all recall, this was a writ challenging the appointment of Mr. Martin Amidu as a special prosecutor, and the basic argument of the writ was that Mr. Martin Amidu, at the time of his appointment, was 66 years old, and by the Constitution, especially in Article 199 of the Constitution, I argue that he is above the age for appointment into the public service. And my point was that the office of the special prosecutor falls squarely within the public services of Ghana. And at the age of 66, he was above the mandatory age of retirement of 60, and then also the voluntary age of appointment on contract of 65. Unfortunately, the precedent that is going to be set will allow for appointments of persons who are over the age of 65 years. Persons who are 70 years of age can be appointed into the public service after they've retired.
So you heard Dr. Dominic Ayine expressing his disappointment. Lawyer Yaopong, let me come to you before I come to my other lawyers in studio. What did you make of the ruling? And I know the opinions have been different on this particular matter.
Well, thank you very much. I think, first of all, we need to commend persons who come to the conclusion that there are disputes in the public, and if those disputes are resolvable by law, the best place to go is the courts, and especially if it's a constitutional dispute, so to speak. We all know that it is the Supreme Court that has the exclusive jurisdiction to determine those disputes. And I mean, the lawyers know that the Supreme Court is not an easy place. You just decide one day that you just going to place a case before them and to prosecute that case. So it takes both spirits to go there. Whilst we encourage the rank and file to be bold enough to go to all the courts, especially where, as I always say, we are lucky enough to be blessed by judges who are fearless, who are bold, who don't determine matters according to people's status in life, whether you are powerful or not. People have lost cases against the state has also lost cases against even unknown individuals. So that said, in the first place, I was able to get bit of the arguments that Dr. Ayine, on record, one of my best teachers, and I read it thoroughly, and I also had the opportunity to read portions of what the Attorney General, through Godfred Akoto, Honorable the Deputy Attorney General, and their team also brought to the court. I wasn't surprised with the majority decision because I fully share in that decision, in the sense that I think that to some extent, the plaintiff, Dr. Ini, may not have adequately addressed the issue of the other category of persons who are also public office holders as defined by the Constitution. And to that extent, I was not expecting that the majority decision may have been different, even though reading the judgment and the certified copy has been made available. I was surprised at the depth of the knowledge, legal knowledge and principles that have been expressed and explicated by their lordships. And I find it highly insightful, because if the decision had been that the office of the Special Prosecutor or the appointment of the head of the office of the Special Prosecution division of which has been created were to be like the normal, and I've used normal in terms of what we know, the usual system that we know, the public services and the rest of them, I think we would have had some problems with other persons also who are defined to be part of the public services or the public office holders, because public office is defined by the Constitution, Article 295, to include an office, the emoluments attached to which are paid directly from the consolidated fund or directly out of monies provided by Parliament, and an office in a public corporation established entirely out of public funds or monies provided by Parliament. And so then how do you classify that? Also, you have to also note that the word include or includes has been the subject of determination, judicial determination, even by the Supreme Court, and has clearly underscored the need for us to also use other principles, and without sounding technical, they use them generic rule and things like that. But then it means that the window is not closed, and that is why the use of the word include is very, very important. So when they said it includes, and then at other parts of the Constitution, it has listed the public services. For example, we have the civil service, judicial service, all those state institutions with service attached to them have been listed as being part of the Article 1901, the public office holders. And then we also have other public office holders who don't fall under Article 190. And earlier on, the Supreme Court had also clarified the matter in the famous Vuivo case. And so when you read it together, I think you come to the conclusion that this matter had already been determined, even by the Supreme Court, and the court had not departed from it. But it appears that that may not have been, or the plaintiff in particular may not have adverted his mind to it. So in the nutshell, in my view, if you ask me, I think that it is all well and good for us. We are expanding the frontiers of the Constitution. In fact, students are very much excited about it because both sides, even and I'm talking about the majority and quote and unquote the minority side, the dissenting opinion, they are very deep indeed. And whichever way you take it, well, by tradition, it is the justices of the higher number whose decision prevails, and not the minority. But if the two are read together, you will learn a lot from it in terms of even the art of interpretation and delivery, and also amalgamation of legal principles that have been woven beautifully together to bring out this, if you ask me, this excellent judgment, even for the dissenting opinion.
Okay, thank you very much, Lawyer Yaopon, for that one. Let me come to you, Lawyer Boabia Samoa.
Normally the senior goes last.
The senior goes last. Okay, then let me leave him there. Today, let me follow your protocols. So, what are your thoughts then on the matter?
Oh, basically, I think that as Yaopon said, it's exciting. If you are a student of jurisprudence, you would understand the fact that the Supreme Court and the judges that make up the Supreme Court have philosophical, and jurisprudential ways of going about resolving issues. And so, depending on the school that normally a particular judge orients from, you kind of see it translated in the kind of decisions that they make. And also the particular rule of interpretation that they may want to adopt. If you look at the majority decision, they took it from the purposive interpretation, or what we call the modern purposive interpretation, where they refuse the Constitution. They wouldn't look at just a particular clause and read it in isolation, but will probably look at the entire Constitution as it is, look at the various clauses that deal with the particular issue at stake, and try to forge a meaning or an interpretation that ultimately does not, in their opinion, lead to an absurdity, or that does not, that actually makes a progressive, a progressive interpretation, yes, and the intent of so, unlike the literalist who will say that, look, this is the wording of the law, and we would interpret it strictly and not look beyond that. You have a situation where, in order for, and it emanates from, if you read the decision, they talk about Tufo and Attorney General, the fact that the Constitution is a living document. It's a document on its own. It's a different kind of document. You don't interpret it like you're interpreting statutes or other subsidiary legislation. You need to make sure that the intentment of the framers is given into effect. You marry that against what the current aspirations of the people are. Where are they trying? So on that score, the Supreme Court does not just look at the words as they are, but then tries to give intent. So they actually would take into account what the purpose for that particular legislation, piece of legislation is. And if a majority of the judges are prone to that school of interpretation, then they would, even if the word says, that's where they are able to even go and rewrite the very activist judges can actually rewrite the Constitution. And if the purists will say, oh, the Supreme Court or the judiciary is just supposed to interpret, but activist judges who feel or who want to employ and deploy the techniques of the modern purposive approach would actually even take the step further of actually putting words in the Constitution that will arrive at that particular purposive interpretation. So in this particular case, what basically then happens was the plaintiff comes in with, I saw a very hard literalist interpretation of the provisions of the Constitution, which for him were clear. Public service, the retirement age is 60. If you are going to be given any extension, 65, period. The Deputy Attorney General, to his credit also, then sought to say that, look, there are different categories of public servants or public office holders, So there was a debate as to what constitutes public office and all that. But at the heart of it is, and in truth, we have different ages for different categories of public offices, because even for the judiciary, you have for Supreme Court, for High Court judges is 60, I believe 62 or 65, and then 65, and then up to Court of Appeal, then Supreme Court is 70. So within the same Constitution, even though that person is a public officer, that person has a different retirement age. On the Auditor General, it was also 60. You understand? The Constitution, the Honorable went to court. What's his name? The former Peace Ofori went to court, and the court said the retirement age is 60. What perhaps must also have informed the position of the plaintiff was also in the respect that the conditions of service, because the OSP, the Office of the Special Prosecutor, is equivalent to a Court of Appeal judge. And so perhaps if you look at the conditions of service and the age of retirement of a Court of Appeal judge, perhaps that should also influence the adjudication of this particular matter. So the plaintiff was looking at that particular provision that says that all public servants must retire at 60, and if you are even being given an extension, 65. Now, if Mr. Martin Amidu was 66 at the time that he was appointed, then automatically he is disqualified on all frontiers, in his opinion. So let me go and challenge this appointment at the Supreme Court. The Supreme Court looked at it, a majority of them looked at it and said, look, if we look at the architecture of the Constitution and we look at the various ages, and there is, in their opinion, no attempt by the framers of the Constitution to prescribe a one-fits-all situation for public officers, and that if you indeed look at the fact that ministers have no age limit, there's no age limit for ministers. If you look at the fact that there's no age limit for the president, if you look at other categories of public officers who do not have age limits, then you may not be, it may not be the true intent of the framers of the Constitution to have a one-cap-fits-all for public officers. And that, of course, there must be some flexibility to allow for the deployment of skills and skill sets when it comes to the employment in the public service, especially if you are looking at what the purpose of this particular office of the Special Prosecutor is supposed to deliver. So they will give a purposive interpretation which will accommodate the intent of what what Parliament and the framers sought to do.
Okay.
So, if you also look at what the minority said, expressed by her ladyship Justice Doji, I think it was a very powerful dissenting opinion, because it was very powerful. She was of the opinion that this was an act of Parliament, and therefore one of the aids of interpretation is to look at the intentment of Parliament. So she went to the Hansard, and if you look at the Hansard and the debates that occurred in Parliament, there was clear evidence that there was every intendment for that particular office to be deemed to be a public office within the understanding of that particular provision, which I think is Article 191, if I'm not mistaken. Yes. So she was of the opinion that if we are to give true meaning to an act of Parliament, then we must look at what the framers or what Parliament intended. And if Parliament intended it to be a public office, then he's bound. And so she and Justice Badebe were prepared to grant the reliefs as sought by the plaintiff. I think that the thing about the Supreme Court is that even though its decisions are precedent, it is not bound by its own decision. And we've had situations where years after, the court has come back, same issue, and has changed its mind. So this is the first step, especially with the kind of dissenting opinion that was given. Maybe we may come back to this situation, not necessarily with the Office of the Special Prosecutor,
a different one,
because as it is, we will continue to create offices and public offices as special vehicles for specific things.
Okay.
Maybe another challenge will come in the future, and we may visit this particular issue. But all in all, I think from an academic point of view, from a legal point of view, it was worth the reading. I mean, they both put in a lot of effort.
Me proposed concluding remarks almost took my thoughts for himself. First of all, every party in the process needs to be commended. And secondly, we have to appreciate that the Supreme Court makes law
Yeah.
in interpreting the Constitution. And so once it comes into being, it is the rules. But clearly, as he landed, we may have to clarify this ruling going forward. Because clearly, I believe it depends on specialist public offices. Specialist public offices requiring special skills. And I think the court was at pains to ensure that no president, doesn't have to be this president, but no president is constrained from creating offices and filling them with the required skills in order to deliver a specific purpose for us. And the OSP in particular is that kind of office. For once, I will go into a bit of controversy.
Okay.
I think the problem started from Parliament. And that is where the dissenting opinion focuses.
Okay.
And Ipapo raised it, that both the majority and the minority were being purposive in a sense. While the majority were purposive in stabilizing the intent of the appointing authority, the minority were also purposive in insisting that the intent of Parliament, even if it's mixed up in the final law, must be given effect to. Well, in that law, and I was privileged to be part of the process, right from the beginning to the end, the question of appointment power and tenure. Appointment power and tenure. So the president appoints under Article 70, and then tenure is given. But the appointment power under Article 70, does it automatically bring every institution established by the president under 190 and the subsequent public offices described there? And if a law in its body gives tenure outside the confines of the public office tenure, implied tenure provisions, what then do you do? Does it imply that it takes it out of that public of, or you can say that the tenure provisions are no good as against the strict public service requirements? You know, we are talking about age. So suppose you appoint somebody to a public office with tenure, but the tenure goes against the age requirements. Are you debarred from doing that? Are you constrained from doing it as a president with your appointing power? I think they were right in saying that the president must be given flexibility. But the controversy I'm looking at is in the rigor with which Parliament established that office and the law. I think the key difficulty is in having established a specialist office and imported the standard structural requirements into the law. And that's where the whole problem starts from. That if we are going to continue establishing offices, and in particular specialist offices, then Parliament must go the extra mile to establish clear authorizations over the appointment procedures, the governing structures, and tenure. Because we are allowed to do that. So that it doesn't come out of a situation where you establish a specialist office and then impliedly, based on one or two provisions which refer to the standard states of public office within the Constitution, you then drag that specialist office back into the standard public service structures. And this is the bifurcation that the OSP law created, resulting in the plaintiff's confidence that they could go in there and change matters. And so going forward, Parliament should be more nuanced in using its powers in the Constitution, in creating things. Because in my short time in Parliament, I think sometimes we're a bit mechanical about some of the things in the Constitution that ought to be or guide us in our lawmaking. If you take something literally from the Constitution and put it in a law, and then you create other things which are not in the Constitution and amalgamate them, then you could have a potential situation where you are bifurcating and clashing the intent and purpose of what you have done. And that's exactly what happened in the OSP, in setting up the OSP. So this decision is welcome, but it must be seen in the context of specialist office and not interpreted to mean that the entire public service retirement rules, age rules have been thrown out of the window. Because some people also have that interpretation. It is not right. It's a one-off to do with this particular office, but it can advise us. That's why I say probably, and I agree with Papo, in the near future, it must be clarified so that we realize that, yes, these are the standards of public office. And indeed, ministers and other people are not appointed by age. They are public officers. They are paid from the consolidated fund. So are they disqualified? They are not. So those other grades of public offices and the kinds of appointment and tenure associated with them perhaps needs clarification going forward.